Good afternoon, everyone. My name is Erin Choquette. I am the CEO of the Connecticut Paid Leave Authority. Jessica Vargas, our Chief Experience Officer, is with us today. We are here to talk about Connecticut paid leave coverage for employees of public school operators. So if you work for a private school, you may want to come to one of the sessions we have specifically for private schools, although you're welcome to stay. Most of the information is the same. We are recording this webinar. You will be able to access recordings of the webinars from our website and our designated YouTube channel. We will be accepting questions using the Q&A function in Zoom. So if you have questions, please put them into the Q&A function in Zoom. Please don't use chat because we can't really access that during the webinar. Although Jessica may share some materials in the chat for you, it's hard for me to review it while we're going through the slides. We will share the materials, including the webinar recording and the actual slide deck with everyone who has registered today. So you will see it. You don't need to ask for copies of the slide deck. We will send them to you. I think that's all of the housekeeping. So I'm going to hide myself so you can see the slides and we'll get started. If we do not get to your question, please don't worry. We are keeping a list of frequently asked questions and we will be publishing that as well. But we have been able to get to most of the questions in these sessions before. Again, I want to make sure everyone is aware this employee is intended for employees of public school operators. The definition of a public school operator in the statute includes local and regional boards of education, interdistrict magnet schools, local or state charter schools, endowed or incorporated academies which have been approved to provide special education services pursuant to Connecticut General Statute 10-76D, as well as cooperative arrangements between multiple boards of education. This does include RESCs as well as other regional schools. We're going to talk about Connecticut paid leave, and then we're going to focus on what Public Act 174, which is the new legislation that will take effect on October 1st, and what that means to you. Then we'll talk a little bit about some of the basics, just so you have an understanding of Connecticut paid leave, as well as Connecticut FMLA. We will make time for questions that Jessica will save for me so that I can address them toward the end of the hour. Again, please use the Q&A function to submit any questions. But first, let's just talk about Connecticut paid leave. The Connecticut paid leave program was created by legislation, Public Act 19-25. The purpose of this legislation was to create a source of income replacement benefits for eligible workers if they need to take time away from their jobs for a qualifying reason. So the Connecticut paid leave program is for Connecticut workers by Connecticut workers. The program is entirely employee funded. Basically, the money comes from a payroll deduction. So if you work for a covered employer, that employer deducts 1/2 of 1% from the paychecks up to the Social Security contribution limit, or the FICA limit. We call these contributions because they are used to fund the paid leave trust fund. So the money comes from the workers, but the employer handles the paycheck. So the employer takes the deduction and remits the contributions quarterly to the paid leave authority. The money is pooled into the paid leave trust fund. This is managed by the state treasurer and invested by the treasurer on our behalf. But it is not considered to be state money. This is separate money and can be used only to run the program and pay benefits. So if an individual needs to take time away from work for a qualifying reason, which I'll define in a few minutes, the worker applies to their employer for job protected leave under FMLA, but they can apply to the paid leave authority for money so that you can continue to pay your bills while you're out of work. We started collecting contributions in 2021 and we started paying benefits in 2022. And to date, we have paid more than $1.2 billion to more than 165,000 Connecticut workers. We receive claims from everywhere across the state, depending on the number of workers in that state and that town, but really we get them from everywhere. It is important to remember that Connecticut paid leave is a different law than the FMLA. Technically, FMLA, or Family and Medical Leave Act, is an acronym that's used to refer to two separate laws. There's a federal FMLA, which you've probably been covered under, because that law has been around since the 1990s, and that does cover school employees. And then there's also a Connecticut FMLA. Up until October 1st, Connecticut FMLA has excluded school employees, but it's going to be amended just like paid leave. The purpose of FMLA is to provide workers with unpaid, job-protected time away from work. Employers can adopt policies that say you have to use your sick time, you're allowed to use your vacation time, or whatever, but the law specifically says the time is job protected, meaning that they have to bring you back when you're done with your leave, but they don't have to pay you. That's a big gap because a lot of people really can't afford to go for several weeks without a paycheck. It's really difficult to do that, right? And so the paid leave program was created to fill that gap by serving as a source of income replacement benefits or money to eligible workers. So our leave reasons are the same, but we serve this money purpose rather than a job protection. I also want to remind you that Connecticut paid leave and paid sick days are different. So there is a paid sick days law. Connecticut passed it several years ago, and it was very narrow and only applied to this definition called service workers, which was a very narrow category. In 2024, the legislature amended the paid sick days law to cover more workers. And it has a 3-year phase-in, but at the end of that time, almost every worker in Connecticut will be covered by paid sick days. Paid sick days says, hey, employers, you have to provide a minimum amount of employer-funded paid time off to your employees, which your employees can use if they need to recover from an illness or care for a family member with an illness. It could be any illness, including routine colds, the flu, situations like that. So it is an employer-funded situation. Many employees already got paid sick time from their employers, but perhaps the restrictions on usage were more narrow than this law. In schools in particular, most schools allow paid sick time for most of their workers, but they have really restrictive rules about when you can use it and the increments you can use it. As I know some schools say you have to use your time in 4-hour increments. In 2024, when the paid sick days law was amended, there was a kind of an outcry. And so in 2025, boards of education and municipalities were able to convince the legislature to amend the law. And under this new 2025 amendment, they say that the increments by which people can use that paid sick time are determined by collective bargaining. So that's all a whole separate law. We're really not going to talk about it anymore today. I just wanted you to be aware of it because sometimes people confuse it with paid sick leave and paid time off and CT paid leave. So CT paid leave is employee funded, as we've just talked about, and it's really used for more serious health conditions. We do have information on our website, which is ctpaidleave.org. And you can also find information on the Connecticut DOL website if you are interested in information about paid sick days, because really we're not going to talk about it too much. What I really want to talk about is how Public Act 25174 affects school workers. Public Act 25174 is actually a kind of aircraft carryover bill. It covers a whole lot of different things. I actually have to get to the very end of it, like the last 5 sections of the bill, to talk about what it does with paid leave. And it does 4 things. First, it establishes that definition of public school operator that we've already gone through. Second, and really most importantly, it requires that employees of public school operators, as well as non-public elementary and secondary schools, who are not required to have professional certification, it requires that those workers be covered under Connecticut paid leave and Connecticut FMLA. Third, it gives the Connecticut Paid Leave Authority discretion to account for alternate pay calendars when determining eligibility and benefits, which I'll talk about in a minute. And finally, it establishes an eligibility requirement for school employees under Connecticut FMLA. Again, I'll talk about that in a few minutes. So as I said, expanding the coverage of Connecticut paid leave and Connecticut FMLA is, I think, the most important part of this law. Starting on October 1st of 2025, public school operators will be considered a covered employer with respect to employees whose positions do not require certification under Chapter 166, which is the statute, the set of statutes that are administered by the State Department of Education relating to certification. It's really important that we focus on the position, not the person. You could be a person who happens to have certification, but you are in a position where that's not required. If your position does not require it, you are covered. And again, it has to be required, not simply preferred or desired, right? You might have a school that says, we prefer to hire tutors or paraprofessionals who have certification, but that is not a statutory requirement to be a paraprofessional. So paraprofessionals are covered. This law also covers non-public elementary and secondary schools, again, with respect to employees whose positions do not require certification. Employees of public school operators and non-public elementary and secondary schools whose positions do require professional certification under Chapter 166 continue to be excluded from the program. So teachers and administrators continue to be excluded from Connecticut paid leave, unless they are part of a collective bargaining unit that negotiates to participate. Unless that happens, teachers are out. And again, this was a legislative decision. We are just trying to make sure everyone knows about it. So if you are a teacher and you are in a union and your collective bargaining unit wishes to collectively bargain, you would bargain with the board. You don't bargain with us, you bargain with your school board. If that happens, you would then notify us so that we know that you are covered. If there are any non-represented employees who are not already participating in the program and the union bargains in, then those non-represented employees come in. But folks who are covered by a different bargaining unit, one that did not bargain for participation, continues to be excluded. This is probably more than you need to know, but if you are interested, you can check out the policies on our website. Basically, the important thing is that any participation has to be on a prospective basis. We can't do it retroactively. The statute that created the Connecticut paid leave program allows for people to bargain in if they work for a school or a town, but you can't bargain into coverage under Connecticut FMLA as enforced by the Connecticut DOL. Sometimes unions bargain for policies that mimic Connecticut FMLA, but you can't bargain into DOL protection. So that's Connecticut paid leave. Let's just talk a little bit about FMLA. Again, you may be familiar with federal FMLA, which has been around since the 90s. Federal FMLA covers entities, governmental entities of any size, which includes schools. To be eligible, even though the covered entity is the school is covered, the individual worker wouldn't be covered unless there's at least 50 or more employees within a 75-mile radius. But generally speaking, most schools meet that. So you're probably covered under federal FMLA, but you might not be eligible. Up until October 1st, school employees were not covered under Connecticut FMLA. But as of October 1st, public school operators in non-public elementary and secondary schools will be considered a covered employer, so they have to follow the law, as to those employees whose positions do not require certification under Chapter 166. So basically, Connecticut FMLA and Connecticut paid leave have the same rules in terms of coverage. So that's the big thing that the paid leave or the 25-174 did. It did two other kind of technical things that help us implement this new program. One of the things it did was give the paid leave authority the ability to establish a rule for determining a worker's quarterly wages. We use quarterly wages for determining eligibility and for calculating benefits. However, we know that some schools allow at least some of their employees the ability to select a payment schedule. So there could be 3 paraprofessionals who all work in the same department in the same school, and one chooses to get paid over 10 months, another chooses to get paid over 12 months, and the third one chooses to be paid 10 months with a balloon payment in June. Well, that creates a little bit of inconsistency, shall we say. So what the Paid Leave Authority has done, we've adopted a rule following a public notice and comment period to say, if an employee is given that option to select among multiple payment schedules, then we will determine the quarterly wages by dividing the annual wages by 4. That way we don't run into inconsistencies based on payment schedule. And we want to do this because those 3 people that I mentioned are all paying the same contribution payment. They all have the same title. They all actually work the same number of days. So they shouldn't be treated differently just because they happen to have this flexibility. So for these workers, we will take your annual wages and divide that by 4 to determine what your quarterly wages are, which helps us determine eligibility and benefits. So you're not harmed by having the summer off, but you're also not given an added advantage either. On the FMLA side, they also made a technical change. Up until now, the only way you could be eligible for Connecticut FMLA is that you have to show you were employed by your employer for at least the 3 months immediately preceding the leave. So the 13 weeks immediately preceding the leave. There was some concern that if you kept that rule for school workers might get harmed and not be able to take leave in the fall, either because there might be an incentive to lay people off in the spring so that they wouldn't have that 3 months immediately preceding in the fall. So for school workers who are otherwise covered under Connecticut FMLA, to be eligible, they just have to show they were employed for at least those 3 months during the previous 12-month period. So again, you don't get penalized for the summer. So those are how the laws changed. Let's talk about what the laws actually do so that you know what you're eligible for come October 1st. For both Connecticut paid leave and for Connecticut FMLA, you can take time away from work and under the benefit program receive money if your reason for leave qualifies. In the paid leave world, more than half of our claims, I know it says nearly 50%, but actually it's more than that, are for someone's own serious health condition. So by serious health condition, we're talking about someone who is receiving some sort of medical care and ongoing treatment for a condition. The definition of serious health condition includes serving as an organ or bone marrow donor. It also includes pregnancy and recovery from pregnancy or childbirth. In practice, we list those as separate leave reasons because it just makes it easier for people. In addition to those reasons, you could take leave to bond with a newborn child or a newly placed child who's been placed with you for foster care or adoption. You can also use bonding leave pre-placement for the time associated with processing the adoption or foster care. A couple things to know about bonding leave: it can be used by both parents, and it can be used simultaneously or consecutively. And it also can be used at any time during the 12 months immediately after the birth or placement. The next most common reason that people take leave is caregiver leave. So this is leave that you would take because you have a family member who is experiencing a serious health condition, and you are there to provide them with physical or psychological care and comfort. Maybe you're taking them to the doctor's appointments, maybe you're home with them, maybe you're visiting them at the hospital. All of that counts. There's also something called military caregiver leave, which is specific to caring for a family member who was injured in the line of duty on active duty in the armed forces. And then we have something called the qualifying exigency leave, which is available to you if your parent, spouse, or child is either on active duty or has been notified of an impending call or order to active duty. And there are 9 qualifying circumstances. They could be attending a welcome home ceremony or a sending off ceremony, or updating your legal documents or your banking documents, or coordinating emergency childcare. Say your spouse is the one who's caring for the child after school. Now they're called to active duty. You need to find them a placement. You can't leave work early every day during the entire deployment, but maybe for the 2 weeks it takes before you can get your child into the after school program, that's a qualifying circumstance. Then there's also something called the Family Violence Leave Act. Technically, this is separate from Connecticut FMLA, but it is a Connecticut law which provides job-protected time for an individual who is a victim of either family violence or sexual assault to obtain medical care or counseling, to obtain services from a victim services organization, to relocate if that's necessary due to the family violence or assault, or to participate in a court proceeding. The statute says that you can take up to 12 days in a calendar year of job-protected time off for these reasons. And if you do need that time off, you can apply to the Paid Leave Authority for money during those absences. Just a quick slide to remind you that the serious health condition covered by Connecticut Paid Leave and Connecticut FMLA really does require that higher level. So it's not just the cold or a flu. You really are talking about being incapacitated in the sense of unable to go to school, go to work, and some sort of ongoing care from a healthcare provider. If you have a chronic condition for which you see a healthcare provider for treatment at least 2 times a year, that counts, which is something most people forget. The other one I wanted to highlight is what we mean by family member under caregiver leave. Now, if you are familiar with federal FMLA or you took Connecticut FMLA prior to 2022, you know that federal FMLA has a very narrow definition of family. It's just your parent or your spouse, a child who is under 18 or who is 18 or older and has a disability under the Americans with Disabilities Act, which prevents them from engaging in 3 or more activities of daily living. So it's a very tight circle. But under Connecticut FMLA and Connecticut Paid Leave, now an employee can take leave and receive benefits for their parent or spouse, for their son or daughter of any age, as well as for their sibling or grandparent or grandchild. You can also take leave to care for an individual who is related to the employee by blood or affinity. Now, this blood or affinity language is really the state's recognition of chosen family. It's a person with whom the worker has a significant personal bond that is like one of those other specific relationships I just listed. Basically, we recognize that you know who is like family to you, not us, not the state, not your employer. You may be asked to give a writing. We have a form, DOL has a form where you say, yes, I need leave to take care of my great aunt. and you say, this is an affinity relationship. My great aunt has placed the role of my grandmother to me, right? It doesn't require much. You could just say that. Um, they can't ask for affidavits. They can't ask for photo albums or videos. It's not the green, the movie Green Card with Gerard Depardieu. It's really just a simple statement. We see this most often between people who are in a significant long-term relationship who are not married, right? Connecticut doesn't recognize common law marriage, so two people who've been together and lived together and are a couple would have an affinity relationship because they're equivalent to spouses. So that's an area where we see this a lot. When I say that you can take leave, I imagine that many people are thinking about surgery or cancer or something where you're out of work for a long period of time. And that definitely happens. And that actually is a majority of the cases who come to us. We call that block leave. They're out of work for a continuous period of time for a single reason. But that's not the only reason that people take leave. They might also need to take leave on a reduced schedule basis. So they're working some of the time, but just not as much as usual. So maybe you work 7 a.m. to 3 p.m., but you have a physical therapy appointment that you need to go to every day, or radiation treatment, or dialysis, or whatever, right? So you just need to leave early every day. Or maybe you can't work on Thursdays, but you work every other day. That's a reduced schedule. You might also need leave on an intermittent basis. So you have a single leave reason. Maybe you have migraines. Maybe you have to care for your sick father. You don't need long periods of time, but when the migraine flares up, you need to go home and take your medicine and sit in a dark room. Or when your father needs an appointment with the oncologist or whatever, sometimes you need to be the one to go with him. That's intermittent leave. It's relatively sporadic and it's relatively small amounts of time, but those absences are covered. So from an FMLA perspective, they can't be used against you from an attendance policy. And if they're unpaid absences, you can come to us to get benefits during that period of time. The total amount of time that you can receive Connecticut FMLA, so that job protected leave, or benefits under Connecticut paid leave, is usually up to 12 weeks in a 12-month period. And the amount of time is dependent on your leave reason. There are two exceptions. A person who is pregnant may have access to an additional 2 weeks during the pregnancy. They could use this for prenatal appointments. They could use this if they've got complications, if they're put on bed rest. Those 2 weeks are sort of a bonus that they can access while they're pregnant. Once the baby's born, the 2 weeks go away. And then, as I mentioned before, the Family Violence Leave Act is capped at 12 days in a calendar year. So that's actually a situation where you get less than the 12 weeks. I've already talked about eligibility for Connecticut FMLA. That's really pretty straightforward. It's no longer about hours worked. It's just about, did you work in at least the 3 months or 13 weeks? Eligibility for paid leave is a little bit more complicated, and it looks at your quarterly earnings, which is why we had to adopt that rule. Basically, a worker must earn at least $2,325 in their highest earning quarter of the base period. And the base period is defined as the first 4 of the 5 most recently completed quarters. We will look at earnings from multiple employers. So if you have part-time jobs or extra jobs, we will look at those, but it has to be from a covered employer. As of October 1st, your schools are covered employers, so we are able to look at your earnings from the past. So don't worry about that. It doesn't have to be each quarter, it just has to be at least one of them. So in this chart, you'll see that if a claim is made between October and December of 2025, we are looking at quarterly earnings from July of 2024 through June of 2025. In addition to having that 2325 in a quarter, which is a 3-month period, you also must meet one of the following. You must be an enrolled sole proprietor or self-employed individual, or you are currently working for a covered employer, or you had been employed by a covered employer at some point in the 12 weeks immediately preceding that first day of benefits. This last category covers or makes sure that seasonal workers, temporary workers, and recently unemployed workers still can benefit from the protections. If you know that you're going to have a leave reason, you can apply now. But if you don't know, or something happens in the future, you should know that you can start a claim for benefits either by going online to our website or by calling the number on the screen. We have a contract with AFLAC. They are our claim administrator. There's a dedicated team at AFLAC that does only Connecticut paid leave programs. So you don't want to call their general line. You want to call this number. Or, as I said, you can go to our website and start your claim then. We have a step-by-step process on our website that you can follow along. We also have videos. We try to make it very easy. But basically, when you begin your application, you'll tell us what your leave reason is and your estimated duration of claim. And you'll receive a notice explaining exactly what documentation is necessary to complete the claim. If you want to get a preview, you can look at the claims website and look at the document checklist, and that'll tell you what's going to be necessary. Generally speaking, for your own serious health condition, we need a medical certification completed by your doctor. So how does this work? Well, you start your application. We send you a notice that you can access. You can ask for it by email or by US mail. We'll also create we have an online portal where you can see everything about your claim on that portal, and you'll get instructions for that. For every claim, we ask for identity verification, an employment verification form, which you get and give to your employer, and then the document that supports the leave reason, like the MedCert. As the worker, you submit those required documents, and as soon as we get those documents, we process the claim and make a decision. Right now, we're averaging about 3 days between when someone submits the documents and when we can make a decision. And if we approve it, the benefits are issued. If you file in advance, and you can file up to 30 days in advance, the benefits will be issued starting on your leave date. If you file after the fact, and you can file up to 45 days after the fact, we'll process that first payment as quickly as we can, and then we pay on a weekly basis. Generally speaking, we issue the payments every Tuesday, but it depends on your bank as to when you'll get them. If you know that you're going to be out, we encourage you to file in advance, because that way you can get everything done before whatever's going on. But again, you don't always know, so you get up to 45 days after the first day you want to receive benefits. If you wait till more than 45 days, you're going to have to give us good cause as to why you're filing late. And basically, good cause tells us sort of what it was that prevented you from acting in this 75-day period. We approve approximately 80% of the claims that we receive. We approve more if we could. The number one reason that claims are denied is because people fail to give us the documents that we require. If that happens to you, or perhaps we deny the claim because we say you're not eligible or you don't work for a covered employer, you can request a reconsideration. And if the claim was denied due to some sort of missing or incomplete documentation, just send us along what was missing. We will reassess, a different team reassesses the recon, and a lot of times they get, because the documentation is in place or we get more information, we're able to approve, which is great. If you get your reconsideration denied, or if you're like, no, I don't want to talk to you people anymore, you can file an appeal with the Connecticut Department of Labor. They are an outside entity. And so they'll look at that case brand new. They do take a little bit more time. We usually get things resolved within a couple of weeks. They take a few months. Just before I finish up and we look at questions, I want to give you a few things to remember. Again, FMLA and paid leave are different. So you apply to your employer for that job protected time off from work to make sure that the job is being held for you and your absence is not being treated as a negative on any performance evaluation. It also helps you make sure that you keep your insurance, your medical insurance intact. And then you apply to Connecticut paid leave for the money. When you apply, look at the due date. It's going to be there on your notice of application that tells you when you need to get the documents in. Generally speaking, it's 15 days, either from when you start or from when your first date of absence, whichever's longer. If you need more time, just ask us. We give everybody an automatic extension, but if you need more time, just talk to us, because we cannot review the claim until the documents are submitted. Fourth, let us know if you've got any changes, if you need to go out sooner than you expected, or you are able to go back to work sooner, or you need additional time off, whatever it is, just let us know and we'll adjust it for you. And then fifth, and this is really important, particularly for school employees, we only pay benefits for dates that you otherwise would have been working if the leave reason didn't exist. So, when I was growing up, Pratt and Whitney always had their August shutdown, right? And so the entire factory shut down in August. That's the reason they're not working, is because the factory is shut down. So if that's the case, you don't get paid by us during that week in August. If you would normally be scheduled to work during the summer, great, and you can't work because you're having knee surgery, then that's covered. But if you weren't normally scheduled to work in July, then that's the reason that you're not working, not anything else. So we wouldn't be able to pay you if you have your knee surgery in July, if the school didn't schedule you to work then. But again, we do look at your multiple jobs. So if you're like, oh, hell, I also have a summer job at, Lake Compounds, well, we would look at that. So just be aware of that factor. Quick summary of kind of everyone's responsibilities. On the paid leave contribution side, the worker pays the money. It comes out of your paycheck, but the employer is the one who handles it. And then we receive it and process it. On the claim side, you as the worker are responsible for submitting your application to us, getting the MedCert or whatever documentation is needed, including giving the employment verification to your employer. Your employer is responsible for submitting that employment verification, completing it and either giving it back to you or submitting it online, either by fax or email. They should tell you what their paid time off rules are so that you can be prepared, but they are required by law not to discriminate or retaliate against you. Okay, so that is a legal obligation that they must not discriminate. We make the claims, and if there's a decision, the DOL will hear it. On FMLA, you're going to work directly with your employer. So you're going to tell them, hey, I need to take knee surgery. I need some time off. They may have forms that you have to submit. Hopefully they'll accept our forms, but maybe you can convince them to accept a copy of the MedCert you gave us. We certainly encourage that. Employers are supposed to process your FMLA claim. They're supposed to give you information about how to apply for FMLA, including posting the required posters. And again, they cannot discriminate or retaliate against you. The Connecticut DOL issues the regulations and they investigate complaints. So if you feel like you've been discriminated or retaliated against because of Connecticut FMLA or paid leave, you can file a claim with DOL. So I'm just going to quickly scan through this, but I see there are questions, so I don't want to take too much time. But basically, this just reminds you, tell your employer when you need time off from work, right? That's important. You want your job to be held for you. Your employer will tell you if you meet the eligibility and what documentation you need to provide. This is not leave approval. This just tells you, oh yeah, you've been working for us for at least 3 months, or for federal FMLA, 12 months and 1,250 hours, and we're going to need a MedCert. You give them that document. You have 15 days to give them that document, but they're supposed to give you a reasonable extension of time if you ask for it. They review it, and then once they have it, they have 5 days to give you a decision. And they're going to have to tell you, are you required to use PTO? Do you have to call in? How often? And then presuming that you did all of this before your surgery date or your due date, once that time actually happens, or if you have intermittent leave each time you have a situation, you're like, hey, I'm in labor. I'm starting my FMLA leave today. And then when you're over, they have to bring you back to your job. Same terms, same conditions, okay? So just be aware that this is the way it's supposed to work. If you have questions that we don't get a chance to address today, or if you think about it tonight, washing the dishes, please check out our website at ctpaidleave.org. We have a lot of information there. We've got videos, we've got FAQs, there's a ton. If you file a claim and you're like, hey, what's going on with my claim? I encourage you to check out the portal because that's going to give you ready access to everything that's going on. Or you can call AFLAC. You can even check on your claim status through their IVR system, but you can also connect with one of the customer care advocates who can talk to you. If you have questions about FMLA, you want to talk to the Department of Labor, either the Connecticut Department of Labor or the Federal Department of Labor. see if there are any questions that came in that I can answer.
Yes. Yes, we do have some questions. So the first one is, how does it work with payment if you do reduced schedule, example, working 3 days per week instead of 5 for baby bonding?
Great question. So for us with our program, we will find out what your total schedule is. And if you have multiple employers, we'll say, tell us your total schedule, adding all the employers together. And so let's say you work 40 hours a week and now you're going to work 30 hours a week. So you are taking um, one 20 or 1/4, 25% of your leave. You would get 25% of your benefit from us. And you're extending out your entitlement because you're using only a quarter of the week. So instead of 12 full weeks, you're taking, or each day that you take off is really just a fraction of that week. So instead of 12 full weeks of benefits, you could actually get significantly more. Just before you go, there's someone with their hand raised. If whoever that is, if you could just put your question into the Q&A, then we can address it.
Next question, does it limit the type of surgery for your own medical leave?
So no, there's no specific limitation on the type of surgery. The real issue is, do you meet the statutory definition of a serious health condition, which is a little bit more complicated than I summarized. It could mean an overnight stay in a hospital. That's an automatic cover. Or it could be a situation where you have sort of, you're out for the day of the surgery. It's an outpatient, but you have follow-up care. You're on antibiotics and you have to see the doctor in 2 weeks. As long as there's like follow-up care, that would count. The only kinds of situations where you really wouldn't be covered would be a true one and done situation where you go in, you have the whatever, the skin tag removed and no follow-up care whatsoever, not even seeing the doctor again. That probably wouldn't be covered because it doesn't meet the definition.
Next question, do part-time employees also qualify, or do you have to work a certain amount of hours to qualify?
Great question. There is no limitation under Connecticut paid leave. It really is about your money. Did you earn the 23.25 in the quarter, in the highest earning quarter in the base period? And then your benefit is based on your highest 2 quarters. So part-time workers, if they earn less than their full-time equivalent, their benefit will be proportionally less. In Connecticut FMLA, they eliminated the hours altogether. And it's really just, did you work at least 3 months or the 13 weeks in the 12-month period?
You, Erin, and I'm also just I put some links in the chat, and I just put a link to the section on our website where we explain how benefits are calculated, because I think that will be helpful in relation to um, just understanding the
Yeah, thank you for
eligibility.
that. It is a lot of math for me to describe. It's a whole lot easier to understand if you see the examples that are on our website.
The next question is from an HR director at a school district who said that they have non-certified employees in a union, like our BTs, parent liaisons, etc. Are they covered or exempt from coverage? They are not certified, but they are in a union that hasn't bargained in.
Great question. They are covered or will be on October 1st because they do not require certification. The whole thing I said about the unions applies only to individuals whose positions require professional certification. So basically, the only way a teacher could come in would be if they're union bargained. But otherwise, we don't care about union status. Well, we never care. That's not a thing that is part of our concern. But the legislation never addresses union status except for the non-certified, the staff who are required to be certified.
The next question is, I work school hours but get paid through the full year. I get 4 paychecks the last day of school for the summer instead of paying us during the summer. Would I make sure my return would be before the last day of school to make sure I get these checks? I am not required to work summer school.
So in that situation, there's a couple of things that prompts in my head. One is if that is a choice that you selected, as opposed to something that was like, this is the way we do it at our school. If it was a choice, we would take your annual salary and divide it by 4 to determine your quarterlies. For purposes of getting benefits, we would only pay benefits for the time that you would normally have been scheduled to work. You don't have to come back to work on the last day of school. Say that you were scheduled to work through June 20th, would have been scheduled to work through June 20th if you didn't have the surgery. We will give you benefits through June 20th. And then, you know, in terms of what your school's rules are about how you qualify for the summer, that's a question to look at for your own contract.
Next question. Our town has municipal civil service workers working as secretaries and other positions and offices in the district. Are they municipal employees and thus not covered, or are they public school employees and thus covered as they are non-certified?
That is a really great question. Um, it really depends on who pays them. So if they are being paid by the municipality, then they are considered to be municipal workers. If they are paid by the school board, then they are considered to be school workers.
We've already addressed this, but there's a second part of the question, so I'm going to read the whole thing. Will I receive 100% of my salary under CT paid leave? Can I use my sick time and CT paid leave to be paid double?
Great question. We do not pay 100% to anybody. And it's just put in the chat, you'll see it's a sliding scale. Folks who earn less than or equal to 40 times the Connecticut minimum wage, when you go through looking at their highest 2 quarters, adding it together, dividing that by 26, those folks will get 95% of their earnings. Folks who earn more than 40 times Connecticut minimum wage, it's a 2-step process where you get 95% up to a cap and then 60% beyond that. But in all circumstances, we cap at 60 times Connecticut minimum wage. So right now, our maximum weekly benefit is about $942 a week. So that's part one. Part two, Connecticut paid leave statute says that an employee can receive benefits from both the paid leave authority and their employer at the same time, provided the total amount does not exceed 100% of their regular wages. Connecticut FMLA says an employer may permit or require an employee to use their vacation, sick time, or other accruals while they're out on Connecticut FMLA. However, the employer cannot force the employee to exhaust all of their accruals. They have to be allowed the option of keeping up to 2 weeks worth. Which goes into the fact that on our employment verification form, we ask the employer, are you paying the employee anything during their leave? If you are getting 100% pay from your employer during your leave, we cannot pay you during that time. Maybe you're only getting 100% pay for 2 weeks, so we'll start on week 3. Or maybe your employer's paying you 50%. We'll say, okay, are you primary or secondary? If the employer is primary, then we will reduce our benefit by 50%. If the employer is secondary, we pay what we pay, and the employer is going to reduce to make sure that the combination does not exceed 100%. So it's a long way around of saying you can get both, but you can't double dip.
What about certified workers like teachers when they work a non-certified position such as coaching? Is the coaching stipend subject to Connecticut paid leave?
Um, just keep me honest here, but my belief is that if your primary job is certified, then that's it. We don't get any money from your non-certified job.
Yes, that's my understanding.
Okay, that's the way we talked about it. I just want to make sure that's what we did adopt.
Okay, so this is again another kind of a two-part. Just to confirm, municipalities paid by the Board of Education are not covered. I am not required to be certified and work for the actual schools, but the Board of Ed pays all the secretaries.
Now, the Board of Ed paying the secretaries means you are a school employee. So you are not certified and you work for the Board of Ed, then you are covered. If you worked for the town and you were paid by the town, then you would not be covered.
For part-time coaches, they are required to have a CSDE, I'm guessing that's Connecticut State Department of Education permit, so they are excluded. Is that right?
So a permit is different than a certification. But we've had a lot of conversations with the Connecticut State Department of Education because the certification process is their bread and butter, not ours. So if you have questions about whether a position is required to have certification, please feel free to communicate with the State Department of Education. There is a designated SDE district email address that people in your school have access to. Even if you don't, there is one to talk to your administration. Um, that's the official answer. The unofficial answer is we're really talking about certification, not permits. So you really need to be thinking about that piece of it.
Our first pay date in October is October 12th. We are bi-weekly. Do we start the deductions October 1st for 3 days, or do we wait until a new pay cycle, which is October 6th? Second pay date is October 24th.
Neither. The entire paycheck that is issued on or after October 1st is subject to the deduction.
I work a second job providing respite about 5 to 8 hours per month. My main job is school-based. Would this affect the application and getting support from Connecticut paid leave?
So if as a respite worker, you are an employee and you get a W-2 from some organization that assigns you, then we will take the earnings from both jobs, and that becomes what we look at for your eligibility and your benefit determination. And we look at your schedule from both jobs to determine what leave you're taking. Maybe you're taking leave from one and not the other, in which case we treat it as reduced schedule. So it affects it, but it doesn't hurt it. If you are a respite worker as an independent contractor, so you contract directly with the families and you get a 1099, we would not look at that at all unless you decided to enroll with us as a self-employed individual, which I didn't really talk about a lot, but it's on our website where self-employed individuals or other sole proprietors could choose to enroll with us so that their earnings come into play. So I know there are some folks who work for schools and then also might have their own private tutorial business or their own private counseling business. Um, you know, that's separate. That's a self-employed situation. We wouldn't look at it unless you enrolled.
I am part of a union and have banked my sick time as we were told this is our short-term slash long-term disability since it can be used under FMLA. We do not pay for this, but we are now paying for a benefit that some of us or most of us already have. Is all this bank time a waste? Some of us have 150 days accrued of as we have been working here for more than 15 years.
Great question. We hear that from municipal workers. We hear that from state workers. Um, most businesses don't allow you to have that much accrual. What I would say is there's a couple of things. First, when you look at the population as a whole, it takes a very long time and a whole lot of luck to be able to amass that kind of accruals, right? One baby, one serious health condition of your own or a family member, and that could be wiped out. So I don't think it's a waste. The other thing is to look at what are the reasons that you could use that sick time. If that sick time can only be used for yourself and not as a caregiver situation, then paid leave is definitely a benefit to you. And third, you need to find out what your school or policy will be about using your accruals. Do you use your accruals first and then come to paid leave for something else? Or do you use paid leave first and use your accruals to top off? That is a district decision. They can decide how to do it. Um, but we definitely see a lot of employers tell their employees, hey, go to paid leave first. Get your $942 a week if you're maxed out, and then use your accruals to get you up to your daily. So you're still using those benefits.
We just have a request for a little bit of clarification on the pay question. Our pay period is October 10th and October 24th. October 10th pay includes days in September and the first 3 days of October. Do we wait and use our October 24th date as all the days are in October?
No, no, your that first paycheck in October, even though it includes September dates, that first paycheck in October is subject to the contribution requirement.
You referenced whether the employer or the authority was primary and how that impacts how much each side would pay. How is it determined who is primary?
So the statute leaves that up to the employer. And then we ask you and you tell us, and that's how we adjust.
It is 3:59 and we have gotten through all the questions.
Terrific. Well, thank
So
you for your attention this afternoon. Again, we will be sharing the slide deck and the recording will be posted. Um, we also have a whole lot of information on our website at ctpaidleave.org. So if you're looking for just more information, if you think that there's a, oh gosh, I really wish I knew more about the documentation requirements, or I really wish I knew more about how contributions are handled, please check out the website. I, you'll probably find the answer there, but if not, there is a spot on our website called Contact Us where you can submit an inquiry and we tell us if you want an email or a phone call back, and we'll get back to you. Thank you so much and have a great afternoon. Take care, everyone.
thank you. Bye.